Yeah, hi, it's Harpreet Singh from Western Singh Law Firm. So the next video, I want to talk about what ways the landlord can use in order for eviction proceeding if it's not related to the non-payment of rent under AB 3088. Just to recap, I think we have looked in the previous video that the state have provided temporary protection for the tenants to be in their home places or be at their rental places in order to deal with the COVID-19 pandemic. And also there are certain requirements the tenant needs to met, either it's declaration of the hardship, and also there needs to be payment of rent of at least 25% for September to January. So these are certain requirement, and still you have to understand the tenants are not waived from this rent. The landlord can get the collection of these past due rent starting from March 2021. It may change if there is some other legislation, but that's the present law at this time. So how about the landlords? Before action, if suppose means if there is whole lot of rent due and tenant has not paid even 25%, so that means the tenant doesn't get the protection that particular law, and there is no moratorium unless if there is in your local municipality there is some other moratorium or some other additional protection for the tenant, then obviously that would apply. But in general, if suppose your municipality doesn't have additional protections, then based on the state law, what the landlord has to do in order to move forward with the eviction proceeding. First of all, the landlord needs to provide notice of statutory rights of the tenant before proceeding for eviction. As you provide your 3-day notice, you need to provide the rights mentioned in a letter that, okay, these are your rights. You need to pay 25% at least. You need to provide the declaration, and also the landlord need to provide a declaration form in the language as it was in the lease. So if you have signed a lease which was in Spanish language, you have to provide that declaration form and also the letter which was explaining the statutory tenant's right in Spanish language. So next, the landlord need to wait for 15 days in order to see that if the tenant provides the landlord back the hardship letter or not. And if the hardship letter is not received, then the landlord can think about to file a action, a civil a eviction proceeding against the tenant, even in residential tenant landlord relationship, because the tenant is not able to, I think, complete all the requirement in order to get the protection which the state law provides. Again, one other thing I like to mention, if suppose the tenant is making about $100,000 income, and it's a high income tenant, and obviously means you have those tenants in Bay Area or Los Angeles where you have those high income, I think, properties. So in those situations, the tenant need to explain, provide documentation, proof about their financial hardship. It's not just about the declaration in itself, they need to provide proof. Because the legislature don't want the high income tenant, they can adjust themselves if they're making still $100,000. So we don't want them to get more protection. So why not they just explain it, how they are still in the hardship, even if they are making $100,000. They can still win the hardship. There's no question, but you need to explain. So once you have all those things, if tenant provides you that, tenant is paying 25% also, bad luck. Still you have to wait till this temporary law expires in January to think about any eviction, or even to think about the collection efforts which would be ongoing in March. However, if the tenant doesn't fulfill all those requirements, no 25% rent, because I think the declaration form in itself, the tenant can meet that requirement easily. It's not that of a big requirement, but you never know. And even means it's still like a new law. So even in the courts, how it would be dealt if tenant brings on the eviction proceeding, okay, just see, this is my hardship letter. So you don't know, means because the court is also dealing with this new law, and people are understanding it's COVID-19, it's difficult for people, maybe they didn't receive the mail or things like that. But still, if they have paid 25% rent, it depends on the judges. Sometimes judges may provide some leniency to tenant. Okay, even if they are in hardship, they have paid 25% rent, yeah, we cannot continue with this proceeding any further. Or even before like a hearing, means the tenant can file a demurrer. If suppose in your complaint you have mentioned that 25% have been paid, and the rent which is due, it's not more than 75%. So in that situation, there can be issues which you have to, I think, consider before filing your action. So there can be, I think, ways even with non-payment of rent if it's below 25%. So next way is, means you can file an action if suppose it's not based on non-payment of rent. If it's just based on violation of some condition in your lease, where you can evict a tenant, if tenant is creating nuisance from long time, or if tenant is creating a damage, a waste on your property, that's obviously, obviously it depends on again on your lease, but those kind of things, you can start a eviction proceeding on that, and that it's not about non-payment of rent. But you have to understand, means certain things can be looked as retaliation against your activity. If you have started that, the tenant can always object to your action that this is basically a retaliation. And if there are facts that some rent is due, if tenant has paid 25%, then the tenant can object, means this is basically, because sometimes what happened, landlord have been ignoring certain activities of tenant from few months, and now they just file the action based on these. The tenant can always say that these activities are motivated, these just motivated to evict me from this place, and I should get the protection of this law. Any kind of retaliation should not be used, because this is not a genuine case of evicting a tenant based on non-performance of certain condition which is non-financial in nature. So this is one of the ways. And again, as I mentioned in the previous video, that commercial tenancy, unfortunately, it's not covered under this law. If there is certain situation, non-payment of rent in commercial landlord-tenant relationship, then obviously the landlord can file an eviction unless there is some other protection provided by your locality in which your property is located. Another thing the landlords need to understand and also keep in mind, you cannot use, even in like a normal eviction, even pre-COVID, you cannot use certain activities to like basically constructively evict a tenant without any eviction proceeding, like locking them out or shutting down the utilities and those kind of things. So because that would provide the tenant a way to just file a counter claim against you, because the law provides $2,500 fine in addition to any kind of fees awarded by the court if you do those kind of activity in order to move the tenant. Because I understand it's very frustrating sometimes if tenant is not paying and you have your payments due, and you are also, I think, past due on your payments. It's really very hard and it's frustrating. Sometimes people use different ways. That's not acceptable under the law, and you would be fined, and there's a whole lot of other consequences. If you bring eviction proceeding, those would be reflected. Obviously your motive, which you have been conducting different activities from long time. So you should not resort to, I think good thing would be you should consult with a licensed legal professional in order to assess and plan what you want to do and what is acceptable under the temporary law, what is not, and how you can plan in future to get certain resolution of your issues related to landlord tenant relationship. Thanks for watching this video. In the next video, bringing again new topic, just in an effort to provide you general legal information, so you can at least have some basic knowledge in order to assess and provide good, I think, factual information to the legal professional you would getting consultation on, and you just understand, I think, what you are getting into if you have better knowledge or at least have basic knowledge about the things and certain terminologies. Thank again for watching this video. See you in the next video.